Welcome to the 9th webinar in the PIBC Peer Learning Network webinar series. I am Raymond Can, PIBC's Director of Policy and Research, and I'll be your host today. I want to first acknowledge that I am hosting this webinar at PIBC's head office in downtown Vancouver, located on the unceded and traditional lands of the Musqueam, Tsleil-Waututh, and Squamish peoples. As you join this webinar from all points in BC, the Yukon, and beyond, please take the opportunity to reflect and acknowledge the truth of the lands in which you live, work, and enjoy. So we have over 300 registrants for this webinar. If this is your first time joining a PLN webinar, welcome. If you're a repeat customer, thank you. This is the third Ask a Lawyer webinar. It's always a treat to have lawyers answer your questions pro bono. In case you're not aware, the province of BC, through a series of legislation started in 2022, has changed the rules of the game for how local governments plan for and enable new housing supply. Planners in local government, the private sector, and nonprofit sector have been busy the last couple of years learning about the new rules and, where appropriate, complying with them. The next big milestone is this December and the requirement for local governments to review and update their OCPs and zoning bylaws in accordance with their housing needs assessments. So I'm going to ask our panelists to turn on their cameras. I am pleased to have Alison Espetveidt of Lidstone, Pam Jefcoat of Civic Legal, Peter Johnson of Stewart McDannold Stewart, and Guy Patterson of Young Anderson. Thank you everyone who submitted questions in advance. So we're going to cover as many of your questions as possible over the next 90 or so minutes. And I'll also monitor the Q&A box for any new questions. To help guide the conversation today, I've pasted into the chat box the 4 segments, which I will cover. So segment 1, hot takes. Segment 2, the OCP and zoning bylaw update requirements. Segment 3, development financing. And segment 4, planning and zoning matters. And finally, this webinar is being recorded and will be posted on PIBC's YouTube channel. So let's get started. So hot takes. So this is hot off the press. Last Thursday, the province introduced Bill 25 that addresses small-scale multi-unit housing as well as short-term rental housing. So this bill is really fresh. We quickly tweaked our agenda to get some early interpretation, analysis, and reaction from the panel. And to help set the stage, Guy has kindly prepared a brief PowerPoint presentation about the small-scale multi-unit housing provisions. So Guy, over to you, and I'll share your PowerPoint.
Okay, thanks, Ray. Thanks for having me. And Ray asked me to do 3 slides, but of course I did way more than 3, but I'll really try to be brief about this. I don't know what you want to call it, but I'm calling it We Meant What We Said, or Happy Thanksgiving. But anyway, Ray, switch to the next slide, and I'll give you what I think are the key changes, and then I'm not going to go into any detail on the last 2, and I'm going to try to tell you what is going on with the first 5, which all of which are, I'll call them kind of tweaks to the housing supply legislation that was introduced 2 or 3 years ago now. The first one is date for compliance on small-scale multi-unit housing changes. The second one is a change to the definition of restricted zone, which, as people may know, is the restricted zone is kind of like the heart of the small-scale multi-unit housing obligations to allow new housing units or additional housing units. Third is it's clarity for what I call CD zones, even though I hate that term. Fourth is site standards, and fifth is parking. But I just wanted to remind everyone the big idea here, at least I think from the province's perspective, is no more single-family zoning. Create more housing, or at least reduce barriers to housing, and get rid of parking. And the way to the government is trying to implement this more housing or reduce barriers to housing strategy is really to say, if a local government zoning bylaw allows a single family house on a parcel, then in the province's view, that parcel is a candidate for more housing units. For those of you who might not know this, it's exactly the same approach the province took when it created the agricultural land reserve. It took all the land that was zoned for farming and said, that's the agricultural land reserve. So now it's taken all the land that was zoned for single family housing and says, that's the land on which you should allow more than just a single family house. Okay, so Ray, do you want to go to the next slide? Date for compliance. So it used to say local governments must amend their zoning bylaws on or after to permit the required additional housing units on or after June 30th, 2024. And for some reason, the province was calling that a deadline, which one judge had an opportunity to scratch his head about. So we weren't the only ones scratching our heads about how the words on or after were a deadline. But anyway, now it says by June 30th, 2026, which is a deadline, I think, more explicitly, but we have a little bit longer to comply. And there's also relief from the OCP consistency rule for zoning updates that are made to comply, and that relief from OCP consistency extends to June 30th, 2027. So that's change number one. Next slide. Change number two is part of the restricted zone definition created, I think, what some local governments were seizing upon as a loophole, because it failed to place within the definition of restricted zone a parcel on which the zoning bylaw allowed a house with both an attached suite and a detached suite. And so there was this 3-unit area of limbo that local governments were excited to learn actually wasn't considered a restricted zone. That's now been changed, so the definition of restricted zone includes a zone that permits a house with an attached suite, or a house with an attached suite and a detached suite. So that's closed a loophole, I would say, in that adding in that new category into the restricted zone definition. This stuff, I'm probably not making any sense to anyone who hasn't kind of gotten pretty deep into the existing legislation, but I'm just trying to really highlight the changes. And I think this is an important change for local governments that have been seizing upon that potential loophole. And if you hadn't been, well, then you don't have to worry about this, and you can start listening later. Anyway, that's a big important change for some local governments that's been introduced by Bill 25. Okay, next one. Some clarity for what people often call comprehensive development zones, also known as multi-use zones. Again, this is all part of the definition of restricted zone, where it said a zone in which the permitted residential use is restricted to blah, blah, blah. And that didn't really, that definition didn't kind of account for some of the nuances where a zone permitted different kinds of uses and different kinds of residential uses in different areas within the zone. So now the definition says it's a zone where the permitted residential use on any parcel of land is restricted to the relevant things. So if you have one parcel in your zone that qualifies for the definition of restricted zone, then regardless of whatever else the zone permits, that zone is a restricted zone by virtue of that single parcel being restricted to those uses. So that's a big, I think, I don't know if it's a change, but it's at least a clarification, if nothing else. But also remember that the obligation, and this is important that the province figured this part of it out too, that the obligation to permit additional housing units only applies in relation to residential use parcels. So just because your whole CD zone is restricted doesn't mean you have to allow small scale multi-unit housing on the commercial part of that CD zone. You only have to allow it on those residentially zoned parcels. So again, you got to be in the weeds on some of this stuff already to understand what I'm talking about. But if you are, then hopefully these changes will make some sense to you. And these are the changes that I think are important to know about in Bill 25, which, remember, has not yet been given royal assent. Okay, next. Site standards. So this is maybe this is minor, I don't know, but there's this authority for cabinet to make regulations respecting things that kind of go beyond simply number of housing units, to make regulations about siting size, dimensions, location, and type of housing units. And now also that the scope of regulatory authority for cabinet includes form or density of housing units. So just a little bit of an embellishment of the cabinet authority to make regulations about site standards that then, of course, further constrain potentially the discretion of local governments to do zoning on their own terms. Okay, next. Parking. I misread this a couple of times, but they've just shifted a provision from one section to another. Now you can find it all in section 525. The new 525.2 is a restatement of what was previously up in 483, I think. But it still says you can't require parking for certain small scale multi-unit housing units close to bus stops, just like TOAs. So you can't require parking for housing in TOAs, and you can't require it for housing close to bus stops, small scale housing. And then cabinet now has either expanded or brand new regulation making authority to sort of further guide local governments in what was previously an unfettered discretion to make whatever parking rules they wanted. So now cabinet again can make regulations telling local governments a little bit more about how to exercise their delegated parking authority. So what I always say about this stuff is it's just really all of this is about constraining the previously broad discretion local governments had to do zoning and parking, with a view to removing barriers to permitting additional housing units. So I couldn't really say much less than that, but I think that summarizes what I would say are the key changes for anyone who's paying attention to this stuff. Okay, thanks.
All right, thank you, Guy. So we do have one question from the audience, but before we get to that one, I want to get some initial reactions from the rest of the panel about Bill 25. I'm just going to stop sharing my screen here for a second. So Alison, why don't you go first?
I think that Guy's description of the legislation is we mean what we said is probably a fair assessment. When I was going through the amendments, my takeaway was that they were primarily clarifications of things that had maybe been stated in either interim or final versions of the policy manual, but maybe didn't strictly accord with what was written in the legislation. I'm curious to know more about Guy's case where the judge scratched their head about the deadline. But yeah, the legislation was introduced very quickly, and I'm not surprised to see that there is some housekeeping type amendments to fix up some of the flexibility that existed in the language in the first draft.
All right, thank you. Peter.
Well, my hot take is simply that I'm just getting tired of reading endless housing legislation bills. I kind of wish they would have gotten it right the first time, but I suppose with legislation of such, breadth and depth, it's unavoidable that, some housekeeping amendments would have to be made at some point. Also, I suppose the extension of the deadline is probably good news for a number of local governments in relation to the SMOO legislation.
Thank you. Pam.
Yeah, I agree with Peter. One of the things, though, I wondered, and maybe, Guy, you might have some thoughts on it too, to the extent that it's clarifying the addition of form and character language to sort of the ability for site standards from the province. I wonder if that's also potentially foreshadowing further constraining the ability to use DPs in those areas. Because there's been, some discussion on, and one of our questions that we'll talk about today is the applicability of development permit areas and how they interplay with small scale multi-unit housing. And while local governments still have the discretion to use DPs and in particular form and character, there was quite a bit of criticism, I think, if you read between the lines in some of the provincial manuals, about the cost and the impact of imposing form and character requirements in respect of SMU projects. And so I wonder if the addition of that language was more foreshadowing and less clarification, but that's more of just a comment.
Thank you, Pam. So let's touch on one question submitted by an audience member. I think everyone on the panel, you can see this question. This is regarding the timeline now for compliance. So the OCP consistency is now due in 2027. Are you referring to the proactive planning requirements of Bill 44 that are currently due by December 31st, 2025?
No, I think the answer is no. I think it's just that if you're amending your zoning bylaw to comply with the obligations to permit additional housing units on land that's within the now revised or clarified definition of restricted zone, then those amendments need not be consistent with your OCP.
All right, I'm seeing some head nods from the rest of the panel. Is that also consistent with your understanding of the timelines? All right.
Yeah,
All right,
that
great.
would have been my thought. I think they would have been much more explicit if they had intended for the December 31st deadlines to be moved.
All right. All right, so we'll get back to some of the audience questions later on, but I want to move on to the second hot take topic. Just really taking a step back, Bill 25, it's simply the latest in a series of really consequential legislation, as Peter alluded to, in terms of changing how housing is planned across the province. So we've all had about 2 years worth of experience learning about, interpreting, and advising about the legislation. And want to hear from the panel, what are 2 noteworthy things that you are seeing in your practice since the enactment of, for example, Bill 43, the Housing Supply Act, Bill 44, SMU, Bill 47, transit-oriented areas, Bill 46, development financing, and Bill 16, inclusionary zoning. Why don't I start with Alison?
Thanks, Ray. I meant to go look up exactly where these changes came from, but I didn't have time. So I'm just going to talk about the 2 changes generally, and hope that I have correctly identified a change that came from one of those bills, because there were a few other bills as precursors or contemporaneous with some of these changes. So I'm doing a lot of work with the sort of expanded ability to require works and services at the time of building permits. I think the change is great, and it's really shifted the focus away from securing essential or beneficial works and services at the time of rezoning, and allowing the focus to shift over to bylaw drafting for subdivision and development servicing bylaws, which is sort of, it's nice to not just be focused on subdivision. And then in particular, the piece that I find very helpful for my clients who have been doing this for a number of years and now have this statutory or express statutory authority to do so, is the new section 513.3, which allows for a servicing officer to require the dedication at the time of a building permit land necessary for constructing and installing sustainable design features and transportation infrastructure that supports walking, bicycling, public transit, or other alternative forms of transportation.
Thank you, Alison.
Yeah.
Over to you, Pam.
Hey, I agree with Alison. One of the ones that I think is beneficial is the clarity around being able to require works and services in connection with building permits, especially for large scale developments where the servicing costs are incredibly high. And while local governments have sort of grappled with the extent to which they can defer works and servicing requirements to later stages in the process to sort of reduce security requirements and facilitate developers moving forward, especially in connection with phase developments or large scale master developments, that explicit authority at the BP stage gives some comfort to approving officers that are looking for flexibility around how to do initial subdivision approvals for large-scale phased plans. So I think that one for me has been a big ticket one. On the flip side, because my practice is less on the planning side, more on the large-scale development transactional side, one of the things I've noticed, and I don't have an answer to it, but it's something that is coming up, is the interplay with developments that are potentially larger scale multi-phase developments where density has been articulated and secured, you know, at a pre-stage through a covenant. And now the interplay with TOA density and those entitlements around transit-oriented density and the, you know, the allowability there, but where they've pre-agreed by way of either a master agreement or something. And and sort of how that interplay goes in terms of moving forward with pre-existing agreements on title that address density in a way that is different than, you know, they predated the TOA regulations, and now we're trying to figure out how to work in the TOA density into those developments where council has sort of approved the whole of a large-scale master development, not contemplating TOA, and where they've pre-agreed to density requirements already. And, you know, council will have to grapple with amendments to those covenants, but not being able to not change things on the basis of density, right? So it's I don't have an answer to it, but I've seen it on a few projects now where this is coming to light, and the parties are trying to figure out the best way to move forward equitably, and so it's challenging. Yeah.
Mm-hmm. Thank you, Pam. Peter.
Yeah, I just want to sort of echo what Pam was just saying. You know, I've been involved in a number of large scale developments in recent years, and just now trying to sort of figure out how the current legislation is going to require, you know, reopening and looking at some of those agreements that are already done and registered on title as covenants is going to be a challenge.
Thanks, Peter. And Guy.
Oh, I thought I was going to be off the hook for this one because I did those slides, but I mean, I think the one thing that I can't help but noticing is that planners are paying more attention to legislation. And are perhaps more interested in understanding what the legislation says and maybe how to get around it. And then I guess maybe one other just interesting observation I found is that it seems like there's like two camps of local governments. There's those that just like hate what the province is telling them to do, and then there's those that are just like so glad that the province has finally told them to do what they want to do anyway. I just find that's just kind of been an interesting sort of two camps that I've noticed, two different responses to this stuff.
All right, thank you. All right, so one final hot take topic for the panel, and this is a really interesting one. And I think quite a few registrants asked about it, and this is really about the Cowichan land decision. So by way of background, in August, the BC Supreme Court ruled that the Cowichan Nation has Aboriginal title over certain lands in its traditional village site in Richmond, and that the Crown grants of fee simple interest on these lands infringes on Cowichan's Aboriginal title, and that the fee simple titles on these lands are defective and invalid. So the court decision seems to be saying that the fee simple interest on a parcel of land can coexist with Aboriginal title until an Aboriginal title holder takes action to enforce their Aboriginal title claim against a fee simple title holder. I'm not a lawyer, so please correct me if I didn't capture the essence of the decision correctly. But I want to get hot takes from everyone on the panel. So let's go around the horn again. Maybe I'll start with Guy.
Jeez. Look, I mean, this is like thousands of paragraphs, this decision. And I think this is not going to answer the question yet about how it might affect development generally. But I think it's like important for everyone to remember that this is like part of a long series of constitutional litigation. And I think you kind of have to understand a bit about, like, you know, what Section 35 of the Constitution Act says, what the Supreme Court of Canada has been saying in a series of cases since like the 1970s, and even before that, to sort of understand this decision in context. And I did see a clip of David Rosenberg, who's counsel for the Cowichan tribes, talking at UBCM about, you know, and he just paints this beautiful picture of the Cowichan people paddling their canoes across Georgia Strait from kind of Galiano Island, Portlier Pass, over to what we now call Lulu Island. And I just think it's so important to kind of understand that the factual background of this case before you kind of dive into thinking about what the legal implications are. I also think the legal implications are not going to be known until the province probably makes some efforts to perhaps get into negotiations, and until ultimately, I think inevitably, the Supreme Court of Canada has a look at this. I don't think we really can know about how it will affect development generally and housing more specifically until then. That'd be my way of avoiding the question. And finally, I do think it's perhaps a bit like I think people are sort of saying, oh well, you know, the Cowichan aren't out to take anyone's land, and they specifically avoided making claims against anyone but the public authorities who held title in fee simple. But I'm struggling to understand how the implications would be different for, you know, Jane Doe, who's a fee simple holder that wasn't named in the litigation, versus the city of Richmond that was named as a fee simple holder in the litigation. It seems to me it does raise questions about it's sort of the whole bedrock of our land title system. But until those questions are answered, and I think they aren't answered yet, you know, it'd be premature for someone as ignorant as me to make any predictions.
All right, Peter, any initial hot takes on this one?
Yeah, you know, consistent with what Guy was saying, I mean, we just received a 1,000-page, you know, decision, very complex, that deals with a number of complex issues. It is all, you know, it's under appeal now. It'll take years for it to go all the way up to the Supreme Court of Canada, where no doubt it will end up. And we may not know for 7 or 8 years what the final outcome of the case will be. That said, I've got a couple of hot takes. Firstly, I know that at some point in the early stages, an application was made by Canada under which notice would have been given to the fee simple owners, the private third-party fee simple owners whose lands have now been found to be subject to this, subject to the Cowichan tribe's Aboriginal title. And I haven't done a deep dive into the procedural aspects of the case, but it just surprises me that the court would have gone so far as to make that declaration affecting private fee simple lands without those owners having been joined as defendants to the action. But I'm not a litigator anymore, so I can't really speak to that issue. I have trouble, and I think it will take a long time for all of us to kind of sort out how Aboriginal title and fee simple title can coexist in the manner that the court suggests it can. And until we have those answers, I think there are some potential implications for housing development of the province. Firstly, I don't know how developers and financial institutions are going to receive this decision, and whether financial institutions in particular will perceive a degree of risk associated with claims for Aboriginal title that they hadn't seen before, and whether that might affect their willingness to lend money for development purposes, or whether it might affect the cost. Borrowing for developers, I mean, I just don't know. We'll have to wait and see how that unfolds. And again, I mean, this is still early days, so I don't think we can make any definitive pronouncements, but it does raise some interesting questions about local government regulatory authority, seems to me, and whether if Aboriginal title is proven through court declaration or an agreement over private fee simple lands, whether that's going to affect a local government's exercise of its zoning and other regulatory powers. At a minimum, whether, you know, there might be an obligation to provide notice of proposed zoning or development changes that might affect the interests of the First Nation group that has or asserts title. So it'll be interesting to see how that plays out. So that's my hot take.
Thank you. Over to you, Pam.
Yeah, I'm going to echo exactly what they said. It's I think very premature at this point to speculate on what the actual outcome is. But like Peter, I agree. Like, it does raise very interesting questions. I mean, we've all sort of been thinking about, from a local government perspective, how UNDRIP will be incorporated into the local regulatory framework, right? And as you know, local governments dealing with fee simple regulatory authority over fee simple lands, and what's the interplay with UNDRIP? And this case, sort of layered on top of that, really raises issues around how to incorporate UNDRIP into the Local Government Act and Community Charter in terms of how you interpret local government authority, whether that's, especially, you know, highlighting for local governments, tax sale, you know, are changes going to be made to the deemed purchaser provisions in the tax sale provisions in the legislation? Road dedications, it's all like sort of what's within the local government's purview, and you know, are we going to see changes around some of those things? You know, in light of this case, it's not going to be anytime soon, but I think that it gives you fodder to think about where in the legislation amendments might be required to sort of address this. And then my only other hot take, which I was thinking about, was, you know, currently we have, well, it's not sort of dual co-tenure with Aboriginal title and fee simple, but we have a sort of, I guess, maybe an example of where fee simple, you know, crown rights coexist with, you know, fee simple title, right? Crowns have mineral rights and tenure below fee simple properties that are reserved in crown grants, and they exist. I don't know how that'll play out, but it's not, you know, there are examples of where dual rights over a piece of fee simple property do coexist. And so I don't know how that would play out in terms of, you know, Aboriginal title and fee simple, but these are all really complex questions, but you know, and I might be retired by the time it goes to the Supreme Court of Canada, so I'm not sure, but other than that, it's an excellent read if you can make your way through the 1,000 pages, both from a historical perspective and just understanding, you know, the framework within which we're all operating and trying to grapple with. So I'd encourage people, if they've got time, to read it. The other thing I would say, and Guy mentioned it as well, is that the UBCM presentation, which was excellent, is available on YouTube. And so you can access it and watch it for free on YouTube. And that's a great way of also sort of further educating yourself on sort of this level of the trial decision.
Thank you, Pam. All right, Alison, you get the last word.
Yeah, I won't repeat the sage words of my colleagues, but the one thing I will just quickly mention is counsel for developers outside, I think, of any specific directions from lenders or you know, maybe in anticipation that this case will impact their developments. I'm seeing asks, you know, contracts go back and forth with black line changes between council, and I'm seeing the word Aboriginal title show up in more places in like land transaction type contracts. So they show up lots of different places, either in a representation or warranty with respect to Aboriginal title being settled or resolved or somehow not an issue. And so advising my clients on whether or not they can give that representation and warranty has become increasingly complicated. But I'm also seeing it, I think, probably in the most accurate through line from the Cowichan Tribes case when it comes to road closure and then conveyance to the adjacent property. There's now, I think, increasing questions about the nature of those road titles. And so yeah, there's some like really interesting property law issues that exist in an academic and sort of philosophical discussion, and now trying to apply the way in which those property law principles were used in Cowichan Tribes to more expansive or like day-to-day transactional kind of work has become, I would say, quite fraught because, of course, acting primarily for local governments, I just always say no, like we were not going to guarantee title, but I think that sometimes is taken, rightfully so, as a concern that that title may not be quiet. And so it is interesting to have those conversations where I think previously there was just nothing said. And so, you know, as various treaty negotiations are ongoing or conversations around reconciliation were happening, that could exist in its own silo. But now a lot of day-to-day municipal functions, I think, as Pam mentioned, it is complicated. It's complicated to make sure that the layering of that work is it includes, for example, the right departments of the municipality who may be working on reconciliation, or later on, one of my questions is about, management and planning processes. I think that mechanism has often been kept apart from some of this day-to-day, business. It's a local government acting as a person, a natural person, rather than as a regulator. And that's now an interesting, it's bleeding more into that day-to-day administrative work.
All right. Thank you, Alison. Thank you, panel. What a great start to the webinar. So let's move on to our second segment here, the OCP and zoning bylaw update requirements. So we received various versions of this question from the audience. Can we submit our homework late, and will there be any consequences? So Alison, back to you. What happens if a local government does not adopt an updated OCP and zoning bylaw by December? And is it okay to have readings done this year with final adoption in 2026?
Yeah. Like obviously I'm not ever in a public forum outside of legal advice going to advise people not to make best efforts towards complying with the deadline. And I think that if you look at the legislation, by and large, the remedies for failure to meet that deadline are for the ministers to step in and start issuing orders. And I don't know practically how quick any minister is going to be to start issuing those orders if you're not in compliance by December 31st, 2025. And so certainly if the gaps that you are facing have to do with the specific date of adoption of a bylaw, which has maybe already received a number of readings and had a public hearing, or if for whatever reason your engagement might be a little slow, there's a strike that is affecting some departments who are not able to provide feedback to drafts of amendments to OCPs on the timelines that may be necessary to meet that deadline. I trust that the province is aware of many of these challenges that are sort of outside of the control of the local government, and there are consultation processes that even with the best of intentions may not happen cleanly and on specific schedules driven by the local government. So you know, if you are not going to meet that December 31st deadline, you should just verify with legal counsel of your own choosing, sort of what your specific risks are, how far along in the process you anticipate you will be. Try to get something on paper in the legislative stream, so that it's clear that this is a, I'm going to call it a technical default rather than a defiance or unwillingness to comply with the deadline, to address sort of your interim housing needs report in your OCP.
Thank you, Alison.
Yeah.
Peter, what are the minimum content for an OCP update in order to comply with the regulations?
Okay, so I'm an old dog learning new tricks, so I'm hoping that if I get any of this wrong, my fellow panelists will jump in and save me. But I think it's pretty clear. So Alison was just talking about the housing needs report. So the deadline is end of this year for municipalities who have received their interim housing needs report. So, I mean, if you look at the legislation, you can read it yourself, but you have to review and update the OCPs to ensure that your, policy statements, map designations, and so on reflect the 20-year total number of units required, housing units required for the municipality over the next 20 years, according to that interim report. And as well, policies respecting, all the classes of affordable rental and special needs housing referred to in the report. So, as a lawyer, all I can tell you is that's what the legislation says. I'm not an OCP drafter. I'm an OCP reviewer. So you'll just have to make sure that the language in the OCP, addresses those issues on some kind of reasonable basis. The other, OCP update amendment issue, of course, relates to the SMU and the transit-oriented area provisions. So as Guy had indicated, the date for consistency between the OCP and the zoning amendments that are required as a result of the SMU legislation is now pushed back to June 30, 2027, assuming Bill 25 becomes law. And again, that's a matter of reviewing your land use designations, mapping, how land uses are defined in the OCP and so on to ensure that they're consistent with the zoning bylaw. And again, this is a matter of addressing the requirement under Section 478 of the Local Government Act that the OCP that zoning bylaws or bylaws adopted and works undertaken by the local government after the adoption of the OCP must be consistent. So what the province did in anticipation of local governments having to enact zoning amendments on a sort of a fast-tracked basis to bring their bylaws into compliance with the SMU legislation, created this exemption from that requirement for consistency. So the window for closing the gap, if you like, and creating the required degree of consistency is now June 30th. As far as I know, the requirement for consistency between amendments under the TOA, the transit-oriented area provisions and zoning amendments that have been made, and the OCP is still December of this year.
Thank you, Peter. Guy, does the adoption of the updated OCPs and zoning bylaws introduce any potential new liability concerns for local governments?
No. I would need to know more about what liability concerns the person asking the question had in mind to provide perhaps more than a one-word answer, but I don't see any new liability concerns. And really the only real liability concern that planners probably have to worry about is negligently misrepresenting what their OCP or zoning bylaw says. And maybe with these fast, rapid changes to OCPs and zoning bylaws, planners might not it might be more likely to not, but that seems unlikely to me. So I think the short answer is no, subject to a more clear understanding of what specific concerns are being identified.
Okay. Pam, if existing OCPs and zoning bylaws already zone enough land to accommodate the 20-year housing needs, is any action required?
And again, my colleagues can jump in if they disagree, but my read of the legislation is yes, because it's not just about the proactive zoning, it's about the alignment of the OCP and the zoning bylaw with the updated housing needs report. So, which the interim housing report had its own deadlines, and they're trying to get everyone onto sort of the same sort of track of timing in terms of providing these updates, and then the 5-year annual updates after that. And so I think the requirement to create that alignment with the updated housing needs reports necessitates updates to both the OCP and the zoning bylaw. And also, like Peter said, it's got to align with other requirements, not just sort of the amount, but the types of housing, the map designations and everything all have to work together. And so I think in keeping with the updated housing needs reports, it's got to align with that. And those reports are required to have they've got methodology now for statistical, like current stats that align with the release of census information as well. So you can see they're trying to sort of bring everybody into a particular time frame to ensure that the reports are current and based on current information, and the OCPs and resulting zoning bylaw changes are also consistent and aligned with the needs reports, which are based on current information. So it's all got to run together.
All right. Alison, I'm just going to skip down one question here. For any previous zoning text amendments to use and density that are currently compliant, do they have to be carried over to the new bylaws?
Yeah, so again, it's always interesting to read written questions because I'm sure there's some context that's missing to the question, but I don't know why you would redo work that is already compliant. And so to the extent that you're carrying it over, or you had maybe engaged with a consultant or the broader community to develop like language or principles or guidelines or statements in and around it says zoning text amendments. So, if you've created specific uses or you've created specific regulations that work well for your community, and they are currently compliant with what the legislation requires, there's no legal need to redo that work. You could simply carry it over. To sort of echo Pam's comment, I think that there does need to be some engagement in the exercise, which is a degree of analysis. And I have noted in some reviews that I've done that while I think a zoning bylaw is compliant with the rules, it can sometimes help to update the language that's being used to talk about the subject matter, just so that if you have a higher level of government, an outsider or a judge who is being asked to look at a zoning bylaw, they're not having to go on a bit of a hunt to find that compliance. And so, in that way, are you carrying them over? These are policy choices. And so if you are struggling with significant investment into what is already there in your zoning bylaw, I think you can just keep it as is, and you can rely on that sort of statutory exercise that everyone on this in this webinar is quite experienced at, likely planners are becoming more familiar with. Or you could just view this as an opportunity to sort of modernize language, just so that it's much clearer that your existing zoning text amendments are compliant with the current rules, or then So then those are two versions of making sure that it's compliant. Or if you want to start from scratch and interpret the province's mandate, as Pam described, as a sort of scheduling exercise where, okay, you've done the work recently, it is compliant, but the province is now asking you to do it again on the timelines that they've mandated and imposed. I think that, that obviously is one, I think it's redundant. I don't believe that that is what's necessary, but you certainly aren't going to be offside of what is required under the legislation if you re-embark on the exercise once again. So, yeah.
All right, thank you, Alison. And speaking of engagement, back to you, Pam. What are the public notice requirements for the OCP and zoning bylaw reviews?
And when you say public notice, I'm assuming the question relates to whether or not engagement is required with the public. So for the OCPs, my understanding is that there's, notwithstanding that they're being updated to implement provincial requirements, that consultation is still required in accordance with the legislative requirements in the Local Government Act. And I think the intent, again, is to ensure that there is a level of engagement at the front end when local governments are doing the updates and proactively planning, future density, future uses, and the amendments to the OCPs. And then for the public hearing requirements, though, those are different. And there has been legislative changes over the last couple of years to simplify, to some extent, the public hearing processes, so required for OCPs, but not for zoning bylaws that are consistent with the OCP. So for projects that are consistent with the OCP, the local government has a choice as to whether or not to hold a public hearing. But for projects that have a residential component or a mixed use project that is at least 50% residential, then they're prohibited from holding a public hearing, with the idea again being doing front-end consultation, but reducing the potential delays that could be caused in bringing a project to fruition by cutting out the public hearing process at the zoning stage if it's consistent with the OCP and it's for residential development.
Thank you, Pam. Peter, back to you. Does a new or updated zoning bylaw have to attempt to meet the provincial site standards for setbacks and site coverage?
Unmute. Currently, no. The legislation requires that local governments must consider the provincial policy guidelines when amending their zoning bylaws to, come into compliance with the SMU legislation. And those guidelines include recommendations and guidelines for setbacks and lot coverage and so on. And the fact that the legislation is cast in terms of, consideration of the guidelines, I think means that there's no expectation or mandatory requirement for perfect alignment between those policy guidelines and the bylaw. But I think that in order to demonstrate that a local government has considered the guidelines, you would, in introducing a bylaw to council, you would certainly want to highlight any dissonance between the bylaw and the guidelines, explain the rationale for not adhering to the guidelines strictly, and that then provides a basis for demonstrating that the council, the board's decision was reasonable in the circumstances. And that will of course change if the cabinet adopts regulations under the legislation respecting siting size, dimensions, etc. of housing units, because those restrictions or those regulations could then impose restrictions and prohibitions on the exercise of those Section 479 powers. So I guess stay tuned and we'll see what, if anything, those regulations say.
Thank you. Guy, over to you. If a neighborhood plan was adopted as an OCP amendment, does that neighborhood plan get repealed when the OCP is replaced?
Yeah, I think the short answer is yes, assuming that when the OCP is replaced with a new OCP, the previous OCP is repealed in its entirety. But if the local government wanted to preserve that neighborhood plan as part of the new OCP, you know, it could do that. The most obvious way would be to include it in the new OCP, just keep it in the new OCP. Or I suppose you could say that the previous OCP is repealed, except for, you know, whatever section it was that included that neighborhood plan. But once the neighborhood plan is part of the OCP, then, you know, it would have the same status as any other part of that OCP. It would also get repealed and replaced, presumably by the new OCP.
Thank you. Pam, you alluded to DPs earlier. So this question asks, should there be consideration of prohibiting development permits for small-scale multi-unit housing projects in light of the potential cost and time required to meet these DPs?
As a local government lawyer, I'm not sure I'm going to answer the should, a further deterioration of local government regulatory authority over housing, centralizing it with the province. I'm going to leave that part of the question alone. But I think, you know, what I will say is, as I mentioned earlier, DPs still apply. You can have SMU projects within DP areas. The provincial guidance, though, does talk about the, you know, recommended practices to ensure that whatever guidelines you're imposing as part of your DP regulatory authority doesn't unreasonably prohibit or restrict the density or the use of density allowed by SMU housing, and that's enshrined in the legislation as well. I think it's section 457.1, but actually says that a local government, certain of local government's powers cannot be used to unreasonably prohibit or interfere with the density for SMU housing. And in that section, it specifically references the DP area powers under section 488. So I think what's interesting there, and that's what I sort of alluded to with this, is that we always, the legislation comes out and it requires local governments to do certain things, and there's a level of flexibility. And it seems like where the province isn't getting the uptick or are seeing that local governments are not, you know, coming, you know, to the forefront as quickly as they like, then more legislation gets put in to clarify or add more standards. And so that's sort of where, you know, I mentioned when you read the province's guidelines, there is some, you know, discussion about, in particular, having form and character guidelines apply to small scale multi-unit housing, and, you know, the impact that may have, you know, in terms of either setback, massing, height, entrances on buildings, and so things that might operate to actually restrict SMU housing. And, you know, I wonder whether we might see, you know, further guidance or legislative mandate from the province regarding the DP guidelines and how they apply. But currently they're, you know, they're still authorized, but the language in 457.1 is quite broad, right? It's unreasonably prohibit or restrict. So that leaves a level of interpretation as to what unreasonably prohibit and restrict means. And each local government will have to determine in establishing guidelines and how they apply to SMU projects, whether or not they're, you know, contravening that unreasonably prohibit or restrict language. So I think it's still a bit of an open question in terms of how you implement.
All right, thank you, Pam. All right, so one last question in this segment, and I'll go to Guy. What consideration should communities with populations under 5,000 people be making? My understanding is that these communities are not subject to, for example, the SMU requirements.
Well, maybe one clarification, I think, as they are subject to section 481.3 sub 3, which requires one additional housing unit. I think that's the case regardless of size of community, but I could be wrong about that. I think it's the 4 and 6 units that they don't have to accommodate, but so maybe it's they get SMU light, Bill 44 light. But anyway, I mean, and what considerations should they be making? that's a bit like the question Pam had. You know, that's a policy question that lawyers don't have to answer. So I'm not going to answer it. But one thing I will say on the previous point is on the OCP stuff, if you look at 473.1, the obligations for municipalities are a bit different than those for regional districts. So just as far as smaller communities, regional districts, slightly different obligations for OCPs under 473.1. So I did want to squeeze that in.
All right, thank you. Okay, so that concludes segment number 2. I'm just going to let the panel get some water. We'll have a brief pause here. Just want to let the audience know that the next PIBC CPL webinar, this is the Continuous Professional Learning webinar, is on the topic of industrial lands, and that's happening on October 29th. Registration is now open, so please sign up. It's going to be a good one. And then the next PLN webinar is scheduled for November 3rd on the topic of affordable housing in this new era of proactive planning. So we have a panel comprising the BC Nonprofit Housing Association, Metro Vancouver, Entre Nous Femmes Housing Society, and a lawyer in residence from Young Anderson on the panel. We have Heather Cower from the city of Abbotsford as our moderator, and registration opens next Monday, so stay tuned for that. And also, please drop us a line at purelearning@pibc.bc.ca if you have any suggestions for new webinar topics, research, or simply to give us feedback. Alrighty, so before we get to the third segment, I actually want to do something lighter, if you will. I want to ask each person on the panel to briefly, very briefly, tell us how you became a lawyer and what drew you into this area of practice around land use and local governments. Alison, do you want to go first?
Yeah. I sometimes describe myself, in fact, as a failed planner. So when I was done with my undergraduate degree, I applied for a series of different sort of, I guess, post-undergraduate degree study programs, one of which was urban planning at UBC. And UBC Law School gave me my acceptance prior to UBC. So out of, I guess, sheer panic, I decided that I would go to law school. But I had worked, like, while I was an undergraduate student, I'd worked for the city of Calgary for an elected official. I basically wrote the community newsletter. And so through that, people are always interested in traffic and roads and what's getting built in their community. And so I had I would say, relatively high familiarity with some of the issues in planning. And then in my summers worked for the city of Calgary again in their land use planning law section. And here I am many years later doing similar sorts of stuff.
Thank you, Alison. Pam.
Unlike most of the panel who are all have a planning bent, I was not. I have an undergraduate degree in military history and international foreign policy. So my dream was to be in the Foreign Service. So how I got from sort of that to local government is a bit of a stretch, but so that was my route and where I was intending on going. I applied to law school as well. And did a joint MPA law degree at UVic so that I would have the public administration side with it. But I had always intended on entering the Foreign Service, but then came out of 10 years of education with a massive student loan and got a nice job at a national law firm in their real estate group, doing a combination of regulatory and real estate and local government law. And thought I'll do this until I pay off my student loans, and then I'm still going to go into the Foreign Service. And 25 years later, I am still doing real estate, local government law, and my dreams of the being an ambassador somewhere are now gone. But I love the area of law, notwithstanding, or I wouldn't still be doing it. But it certainly wasn't sort of my first direction. It just sort of wound up here, and it's a excellent area of law to practice. It's very tangible, especially when you're seeing the build out and development of the community that you're living in and throughout the province. So I really do like it, but it wasn't where I had intended on being.
Thank you, Pam, for sharing. What a great story. Peter, over to you.
Well, I've been, hard to believe, for me at least, I've been practicing law for 35 years now, over 35 years. I started out doing litigation, insurance litigation with a downtown firm in Vancouver, and did some work for the Municipal Insurance Association of BC. We also had one Lower Mainland municipality who was a client of the firm, so we did some work from them. So that kind of piqued my interest in local government law. I spent 4 years as an assistant solicitor with the city of Coquitlam before joining McDannold Stewart in 2001. I've been doing local government law full time since then. So,
thank you, Peter. And lastly, Guy.
Well, this webinar is called Ask a Lawyer. So I'll tell you how I became a lawyer. I was a planner. I got tired of having to ask the lawyers, so I went to law school. That's my story.
All right, thank you. All right, so on to segment number 3, development financing. So we have 19 questions remaining in our remaining 2 segments. So let's try to get through these briefly and quickly. We have about 20 minutes remaining. So next question, over to Guy. Are community amenity contributions still an available tool for use during the rezoning process? And just a follow-up question, will local governments be required to transition away from existing CAC frameworks? Let's start with that.
Okay, I'll try to keep my answer brief, but I think to the first part of the question, I think the answer is yes, because to the extent that CACs have any legal basis, it's the basis is in not having to say yes to any particular rezoning application, and therefore being able to accept CACs as persuasive in deciding to say yes when you don't have to. So as long as you don't have to say yes, and now we know that the housing supply legislation has forced you to say yes to certain rezonings, but as long as you don't have to say yes, I think there's room for CACs to operate the same way they always have. So then no, not required to transition away from existing frameworks, except to the extent that you've lost your negotiating power. And this is subject now to the recent decision in Lorval and Langley, where the court said that at Langley's apparently mandatory CAC policy was offside. But I don't think that case necessarily means no more CACs. It just means you can't have a policy that a court could characterize as being a mandatory CAC policy.
All right. Alison, can you provide an overview of the in-stream legislative protections for ACCs and how do they apply to multi-phase projects?
So I'm going to start with the second part of the question first, because I suspect that probably is the more interesting part of the question. And the answer to how the rules apply to a multi-phase development will largely depend on whether or not that multi-phase development was done through a phase development agreement, or if it is just a multi-phase development that is a development that is happening in multiple stages. If there's multi-phase development, presumably you will have decided on which bylaws are to apply, and there may be some different protections in relation to the applicability of bylaws. And so for later phases, there may not be an opportunity to collect ACCs if that is a new bylaw that wasn't in existence when that multi-phase agreement bylaw was initially adopted. If it's just a multiple phase development that everyone agrees is a development that is happening in multiple phases, the general rules are that it's the legislation that applies as it is on the date of the relevant municipal approval. So again, depending on how your multi-phase is set up, it could be zoning, it could be development permit, it could be subdivision, or it could be building permits. So the general rules are the same as development permit excuse me, development cost charge rules. So there's a definition of in-stream development. I would encourage you, if you have questions about whether or not ACCs are applicable to a particular application, to go read that definition. It is, I would say it is the most normal category of in-stream type of things, but it does not include everything. So for example, I've answered questions about things like if you have an in-stream, like a heritage revitalization agreement bylaw, that's not referenced in that section. There's a few other like little quirky municipal approvals that may be part of a particular file that you're dealing with that are not expressly included in that section. So if an application is in-stream, the rule is that if you have an initial ACC bylaw that would otherwise be applicable to the construction or alteration of a building or structure, it has no effect. For an in-stream application on the date that the initial bylaw is adopted, and if you have an amendment that is going to change the rate, there's basically sort of a 12-month waiting period or another date as prescribed by the regulation, like a standstill period after the adoption of that amendment. So they basically get the old rate for a period of 12 months. So again, depending on whether or not you are a community who quickly adopted an ACC bylaw and are now amending it, maybe because you have more fulsome analysis or you've done different consultations or those numbers are changing, the rules will be slightly different as compared to a community who is implementing an ACC bylaw for the first time.
Thank you. And Peter, on a related note, this is a very similar question. Would ACCs apply to a project that has already secured community amenities through the rezoning process approved prior to adoption?
So again, I don't know all the background to the question, but I'm going to answer it on the assumption that this zoning bylaw was adopted before the ACC bylaw was adopted, and that we're not, concerned with any of the in-stream or precursor application issues that Alison was just talking about. I think it's really a question of, or as I'm interpreting the question, it's a question of whether the fact that a developer has promised certain community amenities through a rezoning process, and assuming they've been secured through a covenant or something like that, whether, the municipality turns around down the road and adopts an ACC bylaw, and the developer is now saying, well, what gives? I've already promised you all these benefits, and now you're going to be extracting further money from me. That's not fair. As I read the legislation, it's really going to come down to whether those ACC, and again, assuming there's no building permit that's been applied for, there's no in-stream protection or no precursor applications, and that's the starting point to determine whether there's a question of whether the ACC bylaw applies, because obviously if the bylaw is adopted and there's a building permit application in stream, then the answer is, well, the bylaw doesn't apply. If you're not in that situation, then I think you're really, having to look at, well, what were the amenities secured under the zoning bylaw, and what are the amenities that the local government is seeking to recover funds for through the ACC charge. And if there's an overlap, I think, the general principle against, double recovery would likely apply. And you'd have to really carefully look at the legislation to see if one of the exemption or exception provisions would apply. So, for example, there are, provisions that exempt a developer if they've already paid an ACC in respect of that particular amenity. And if a developer has already contributed, either facilities or actual works in support of that particular amenity, or is paid through a voluntary contribution, I think you probably have to count that as, an amenity contribution. And there are also provisions under which you can enter into an agreement with a developer under which they actually provide the amenity instead of paying the ACC. I think you'd have to then look also at the arrangement that you made under the rezoning to see whether it, that fits within what the developer has already agreed to. But, if there isn't, if you're not in a situation where you're sort of, in a double recovery situation, and you're not in a situation where they'd be exempt as an in-stream, or there's an in-stream application that would give them protection, the 12-month protection, then I look at the legislation and say, well, I think they'd have to pay. And there's no, I mean, you can't waive an ACC. So if it's required, except in particular circumstances. So even if you feel sorry for the developer in those circumstances, I think they'd have to just suck it up and pay. Presumably you'll hear from them when you're doing your public consultation and putting the ACC into before council.
All right. So Peter, just staying with you on this one, can the ACC provisions be used to require the conservation of a heritage building on site to which an ACC bylaw applies?
Well, I think there are two ways of approaching this question. So firstly, conservation of a heritage building would not qualify, like a privately owned heritage building would not qualify, I don't think, as an amenity for the purposes of Part 14, Division 19.1. I don't know that it would fit within the definition of amenity to begin with, but there's a provision in the legislation that says, an amenity for which funds are raised through an ACC must be either owned by a local government or, by somebody who's entered into a partnering agreement with the local government. So I don't think you could recover ACCs to use that legislation to protect or require the conservation of privately held heritage property. Now, that said, if you look at the heritage conservation provisions of the Local Government Act now, and assuming this is, a property that's been designated for protection through a heritage protection bylaw, or if it's in a heritage conservation area or something like that, there's a circumstance in which a heritage alteration permit is required in order for work to be done in the building or for the site to be developed. There are provisions in the Act that would allow the heritage alteration permit to supplement or vary the provisions of an ACC bylaw. And I think as I read the legislation, that would give the local government the opportunity to adjust the requirements of the ACC bylaw as an incentive to the developer to conserve or to actually do conservation work on the property.
All right. All right. Last two questions go to Pam here. Can ACCs be charged at subdivision and building permits?
And the answer to that is yes. The legislation specifically says that they can be collected in connection with the approval of a subdivision or issuance of a building permit. And I'll keep my answer short just because we're running out of time. The province has put out a best practices guide for calculating ACCs, and it's very similar to the old best practices guide that was put out for DCCs some time ago. They've done a companion guide for ACCs for elected officials as well. And in there it sets out, and I would encourage people who are considering implementing ACCs through bylaw to review the best practices guide. But that sort of sets out all the considerations to think about in terms of the timing of when you're considering imposing them, whether it's, at subdivision, as you note in your question, Ray, for low density development, and at building permit for multi-unit developments, very similar to the considerations that would be considered for DCCs, although amenities are slightly different when you're considering the timing of when you want to collect, right? Because not all amenities need to actually be in place at the front end. And so considering the phasing and the timing on which you require the amenities and the impact, the financial impact on the developer, those are all parts of the considerations, and there's detailed information about how to calculate them and how to kind of come up with an approach and a regime in the best practices guide. So I just encourage everyone to look to that.
All right. And one last question to you, Pam. You're getting all the philosophical questions today. To what extent do ACCs constrain or clarify local government discretion in negotiating developer contributions?
Yeah, that one you could answer a few different ways too. I think if you're looking at it as, do they constrain? First, it's kind of what Guy was saying, right? If the negotiation of developer contributions takes the form of community amenity contributions in a rezoning, then not constrained. But with respect to ACCs, they're imposed by bylaw and they're front-ended. It's not a negotiation. The ACC is developed through a stakeholder consultation process, the implementation of them through bylaws. So at the time of the approval or the subdivision approval or the building permit issuance, it isn't a negotiation of the amount because they're already pre-established and set out as rates that are applicable in the bylaw. And, as part of that, if we're talking about like constraining and setting them, I'm not sure it's constraint, it's just accountability, I think, in terms of how those rates are charged and all of the different considerations that have to be, come into place when local governments are determining how to set their ACC rates. And that is included in, the phasing of amenities, whether I was just reading, the impact on affordable housing. And so there is very specific criteria that local governments have to consider when they set those rates. So it's not a freewheeling negotiation as some of the CAC setting has been historically. But I'll leave it at that so that we can get on to some other questions before we run out of our 7 minutes here.
Awesome. All right. Thank you. So that's segment number 3. Let's move on to our final segment. We still have a dozen questions, 7 minutes remaining, so we'll do our best. I'll ask everyone on the panel to be brief and to the point. Peter, back to you. And this question is not, I admit, not worded very well. Can a local government redesignate properties within a transit-oriented area from RS into parkland without any public engagement?
Yeah, I was scratching my head a little bit about this one, and I'm not really sure I understand the concern here, but this is what I came up with, and if any other panelists wants to jump in quickly and steer me in the right direction, please do. So yeah, to the extent you've included your transit-oriented area and land use designations within an OCP, and if you were proposing to amend the OCP land designation, I think you'd have to have public engagement via a public hearing. So, and similarly, if you were rezoning from a residential land use category to some kind of park designation, I think that would require a public hearing. I don't think the prohibition against holding a public hearing would apply. But I'd want to know more about the intent behind the proposed redesignation, because one thing is to keep in mind, if you're moving to a designation of land and the designation would restrict or confine the use of the land to a public purpose, then you'd need to be looking carefully at the provisions of the Local Government Act that may trigger a requirement to pay compensation. If the redesignation is a matter of like the application of the subdivision provisions of the Local Government Act, then I don't think public consultation would be a requirement in that case.
All
Hope
right.
that helps.
Thank you. Next, Alison, are there any legal risks for local governments using pre-approved plans to fast-track development?
Yeah. It's very clear that the existing law in and around liability in the context of approval of building plans has not changed as a result of both the federal government and the provincial government creating these quote unquote pre-approved plans. So to the extent that a building official is being presented with these pre-approved plans, there is no change in that building official's legal responsibilities to ensure that the plans presented for approval are consistent with municipal bylaws and consistent with the building code. I would very much like for higher levels of government to create some kind of like assurance program in the same way that a lot of our municipal clients have like letters of assurance from professionals who say, yes, I've reviewed the plans and I am verifying for the purposes of reviewing and issuing building permits that the plans are compliant with the local bylaw rules and the building code. And in that way, if there is negligence in the review and approval of those plans, it is the registered professional who takes on that responsibility. Without a sort of corresponding taking on of responsibility or acceptance of risk to another entity, be it, you know, the organization that put out those pre-approved building plans, a different level of government. A building official is in the exact same plan or exact same position with pre-approved plans as it would be for sort of individually created plans. I just don't see that there is any like inherent guarantee or assurance that is being provided to that building official that those plans are proper. I stand to be proven wrong. Like, I don't know if they're copyrighted or if they're protected and incapable of being altered. Often a building plan depends on site conditions. I don't know who's verifying the suitability of the pre-approved plans for site conditions. There's a case out of Ontario, which I follow closely, where a municipality was found negligent because they issued a building permit that, again, it was an accident, but obviously the application didn't propose someone was going to build a house encroaching into their neighbor's yard. But the fact pattern that the court found was negligent was that as one of the inspections, when the foundation was first laid out using like pins and flags, very clearly had that encroachment into the neighbor's property. And so it was negligent for the building official to have come and done an inspection that allowed for the encroachment of the house into the neighboring property. And so that is totally distinct and unconnected to the pre-approval of the safety of a particular set of building plans.
All right, thank you, Alison. So we're at time, but is the panel able to stay an extra 5 minutes? If so, let's continue with the questions here. Pam, you get the next couple questions related to covenants. So the first one, can local governments require covenants as a condition of land use amendments, even if the applicant does not volunteer one?
I'm going to say yes, absolutely. Especially in the context of rezoning. If we're talking about a land use amendment in the context of a discretionary approval, then that's part of one of the asks. And it's very typical that they are used that way, often in the context of, especially for the types of projects I work on, which are large scale development projects, a lot of the promises and deliverables and obligations of the developer aren't necessarily delivered in connection with the timing of the adoption of the zoning bylaw, but they'll be provided later. So for example, a developer agrees to, remediate a site, provide a road, construct affordable housing, put some public art in, put in an end of trip facility, you know, all of those types of things, to the extent that they're getting the entitlement of the rezoning at the time of adoption, but they haven't delivered their deliverables or met their obligations as part of that exchange. Those are secured by covenant, so that we can make sure that they actually hold up their end of the bargain. So that I would just say is to keep it short, yes. Yes,
Okay.
and it's very common.
All right. Next one. May a developer voluntarily place a covenant on title on their property that restricts density to below 4 units per lot? So an example would be a proposed subdivision where the applicant cannot meet the servicing requirements if each lot were to have 4 housing units.
This one, I could answer this in a couple of different ways. I think keeping it short, I think if it's just a voluntary covenant to restrict density on the lot, the developer can volunteer it. The local government shouldn't be asking for one, and the province would be, their guidance says don't ask for one if it's in the context of restricting density on SMU properties. But in the context of servicing, I think probably yes, they can, if they can't service to that level at the time. And part of that relates to the BP requirements too, now that local governments can require servicing at the building permit stage. I think, there is some flexibility to say, yes, the subdivision can occur, but we want to ensure and constrain the further development to a particular level of density without the servicing being in place yet. And that may come at the building permit stage. Servicing can be imposed at BP stage, or you can secure it with a no BP covenant to ensure that no further building is approved unless the requisite servicing to service that site is provided or security put up and so on. So that's a very quick answer to a kind of a complicated question, but.
Appreciate it, Pam. All right, Guy, you get a couple of questions related to public hearings. First one, under the LGA section 467-1, if no public hearing is held, must the notice still be published twice before first reading?
You're muted, Guy.
Sorry, you got to look at section 94 of the community charter. If you have not adopted a bylaw for providing notice by an alternative means, which you can do if you want, but if you haven't done that, then the default is 2 consecutive editions of a newspaper. If you have your own alternative means publication bylaw, then you publish in accordance with that bylaw, and it might not necessarily require 2 publications of the newspaper, because it might be an online or electronic publication.
All right.
So it depends on, you got to look at 94 and your alternative means bylaw if you have one. Can I just go to the next question? If waiver does the notice. So the question is if a public hearing is waived, but that's not the right word anymore, just to be fussy. But if you're not holding a hearing, does the notice only inform the public, or must it also invite feedback? It need not invite feedback. But that's not part of the required content of the notice. Next question, can you clarify when a public hearing is prohibited in the context of a mixed-use development that's not small-scale multi-unit housing? So Pam mentioned earlier, it's prohibited if it's consistent with the OCP and it's at least 50% residential. And that's floor area, I'm pretty sure it's measured by floor area, residential floor area. So mostly residential. And then finally, since public hearings are no longer required in rezonings, when is a council able to speak publicly about a development proposal? In my view, a council is never prohibited from speaking publicly about a development proposal, regardless whether there's a hearing or not. I think what the question might be alluding to is the problem about receiving new information after a hearing, which I think is different than a council speaking publicly about a proposal. So so a council, in my view, councils can always speak publicly about development proposals, provided they're not having an illegal meeting, or being defamatory, or revealing a closed mind, or revealing confidential information.
Awesome. Thank you, Guy. So we're at time. We only have a few questions remaining, so we'll save them for the next Ask a Lawyer webinar. I just want to thank everyone in the audience who spent your extended lunch with us. Really appreciate it. Again, our next PLN webinar is on November 3rd, Affordable Housing in the New Era of Proactive Planning. Your host will be Heather Cower. Again, everyone, have a good rest of your day and see you soon. Thank you.